Hi, I'm Kate McAuliffe. I'm a Senior Associate in Mason Hayes & Kearns Healthcare and Medical Law team. Today, I'm sitting down with my colleague Kate Maloney, an associate in the team, and we're going to discuss the Civil Justice Review Group, which issued a report last year, making recommendations for reform in many areas of civil justice and litigation. A number of these recommendations will potentially impact the landscape of healthcare litigation. Recommendations have been made for group litigation, which is actually what we're going to talk about today. So Kate, before we get into a discussion of the recommendations, you might just describe what the current situation is in Ireland with regard to group litigation.
Absolutely, Katie. So for those of us who watch legal dramas like Suits or anything like that, when we think of group litigation, we probably envisage the US class action process. We probably imagine a big boardroom full of plaintiffs coming together and bringing one case collectively against a defendant. We have no such process in Ireland. There are some alternatives. For example, there's the option of a representative action, but the requirements for that are very strict, so it's not always suitable. Sometimes we see test cases being brought, like the swine flu vaccine case a few years ago. The thing is, though, with test cases, while they test the waters of the legal arguments, they don't get rid of the requirement for each plaintiff to take their own case subsequently. In recent times, though, we have seen a number of examples of ad hoc alternative dispute resolution bodies being established in situations where there's been a large group of plaintiffs impacted. We saw this in the army deafness cases a number of years ago, again with defective hip implants, and then even more recently with the establishment of the cervical check tribunal. Those bodies, though, they operate outside the court system as an alternative pathway. The recommendations of the review group, they would see a mechanism for group litigation within the Irish court system itself.
Okay, Kate, so you've mentioned that what's envisaged is a group litigation process within the court system. What exactly do you think this is going to look like? Is it going to be like the United States class action system that we see on the TV, like you've just mentioned?
Well, the review group did consider whether the US class action process would be suitable, but ultimately they decided it just wasn't the right fit for Ireland. So instead, they followed the recommendations of the Law Reform Commission, and they've recommended that we follow the procedure in England and Wales. And that's a model called the group litigation order. And with the group litigation order, plaintiffs do bring their own case to begin with, but once they've initiated their proceedings, they can then sign up to a register. The common issues can then be dealt with by a lead solicitor appointed by the group. If there's any discrete issues for a subgroup or even an individual plaintiff, separate legal representatives can deal with those issues. But it means that for the common issues, each individual plaintiff does not need to be separately represented, and the defendant only needs to deal with that one lead plaintiff solicitor. Importantly, as well, the review group has recommended that the action can only be settled where the terms of a potential settlement were agreed by the members before they joined the register, and the court needs to be informed of that agreement. So it does really have the potential to be a very transparent process from the beginning.
Okay, and then in terms of benefits, why would plaintiffs and defendants want to opt for a group litigation order at the outset?
Well, Katie, put simply, the way we see it, the potential benefits of the proposed group litigation process are threefold: time, money, resources. Time and money for both plaintiffs and defendants, for everything from investigations, pleadings, discovery, all the way through to arguing the case in court. The proposed process means that instead of each plaintiff having to make their own case and the defendant having to defend their case over and over again to multiple plaintiffs, this would all be done collectively. Court resources are obviously really important too. And think about it, if there are 100 plaintiffs proceeding separately against the same defendant, that's a huge burden on the courts. If those cases can be progressed collectively, that's going to make a big difference.
Sure, yes, certainly these recommendations could have a big impact across the board, both on plaintiffs, defendants, and the court service. What kind of claims do you think this system would be suitable for?
Really, you name it. If there's a group of potential plaintiffs likely to be impacted by the same situation, there's every chance a group litigation order might be helpful. From a healthcare perspective, cases like the ones that we mentioned already that have resulted in the ad hoc dispute resolution mechanisms might be suitable. Things like the army deafness claims, the defective hip implants. Similarly, things like vaccines or product liability, whether it's implants or surgical tools, those cases could all work really well under a group litigation order. But beyond that, England and Wales have seen their model deal with cases in consumer-focused areas across the board, including product liability, tax disputes, environmental claims, and industrial disease claims. They've really seen them all.
Okay, so definitely far-reaching implications for a wide variety of disputes. When do you think we might see the group litigation order becoming a reality in Ireland, Kate?
Really, only time will tell if or when the recommendations will be implemented. The recommendations were first made by the Law Reform Commission back in 2005, but we've seen a lot more publicity and attention to the idea in more recent years. A multi-party actions bill was proposed in 2017 to provide for a process similar to this one. And that's partly what triggered the question being put to the review group. So there is definitely interest out there in getting this off the ground. As well, it's really helpful that we can look to the experience in England and Wales. By 2019, they'd seen 105 group litigation orders. So there's plenty out there for Ireland to base our decisions on and for us to learn from.
Okay, well, we'll certainly be watching the space for further developments. Thanks, Kate. So we hope you found this discussion interesting. If you'd like to discuss how group litigation might impact you, or indeed any aspect of healthcare litigation, please reach out to one of us in the Healthcare and Medical Law team in Mason, Hayes and Kern.